it's just important to keep that fact in mind, that a lot of what Stephen is talking about, the deception, the obfuscation, happened even as emissions were skyrocketing. So again, this is sort of a connect the dots exercise here. So we've got attribution science. So then, Yvonne, how did your city attorney's office, along with outside counsel, how do you then take these dots and connect them and then make an argument of sort of demonstrating essentially like a tort, or demonstrating, I guess, a public nuisance? I wonder if you could talk a little bit about, just in lay terms, sort of, how you then took all these dots and make a case saying, and you must pay. And what's the sort of the legal argument you use there?
So the attribution science was really important because it was able to pinpoint particular actors, right? So lawsuits, as we all know, are filed by plaintiffs against defendants, but not nameless, faceless defendants, right? They have to be identifiable and responsible. And so the attribution science assisted us in really focusing on the largest actors. Then public nuisance itself, it's a very, very old doctrine. It's a doctrine that's been around for a long time. It is available to private individuals as well as to governments like cities and counties. And it essentially says that anything that is injurious to health, offensive to the senses, or interferes with what the statute says, one's quiet enjoyment. That is all sorts of different things, right? Sometimes that is housing conditions that tenants live in that have mold and substandard building conditions. Sometimes we had a very large case involving lead paint manufacturers, where manufacturers were promoting lead paint for use in residential structures. Sometimes that has to do with criminal conduct that constitutes a nuisance for a particular neighborhood or community. In this context, it is a doctrine that its agility makes it applicable here to climate change. And so, again, nuisance is it's a doctrine that has to apply, that generally applies to real property, not always. And so San Francisco, because of these conditions caused by defendants, are going to have to incur costs to reinforce seawalls and deal with additional flooding. We haven't talked about this, but right, one of the consequences of global warming is also the intensity of storms. It's not a direct issue in our case, but it certainly will be something that will tax sewer and water containment systems across different cities. So we took this agile doctrine and we applied it in a new way. Again, whenever you stretch a doctrine in some way, sometimes you have courts that adopt your view early and sometimes not. It is clear that because of attribution science, that these 5 fossil fuel companies that are defendants in our case have through their manufacture of fossil fuels, have created a situation which is contributing substantially to global warming and therefore to sea level rise. And so we believe that it is those facts lead to a public nuisance. The other thing that I want to reiterate that my colleague said was the deceptive statements, right? So there were, again, this is not, our case is not one of, it's not one that is directly about those deceptive statements, but it certainly raises them because at the same time that production was increasing, you had denial of what scientists were coalescing around. You had not just direct denial, but kind of continuous misinformation that was informing or misinforming policy decisions that were made across the country in our different state legislatures, in our different city councils. And so that is an aspect of the case that's really important not to ignore, because it wasn't just the nuisance occurred and this was an inevitability of our post-industrial revolution. This was a calculated effort to increase production when these companies knew this was going to be the path that we were all going to be on. Unfortunately, we were all the last to know. And so now we are facing this inevitable situation. And it's not that San Francisco is seeking damages. We're not. We're not seeking damages in the traditional sense. What we are seeking is something called an abatement fund. So we're saying to these 5 fossil fuel companies, you caused this condition, now contribute to the adaptations and the ameliorations that we have to do. So help us fund this seawall that we're going to have to build around our, 3 sides of our 7x7 city. So San Francisco is not looking to line its coffers with unrestricted monies. This is a case where we're seeking to have these companies contribute to the capital costs that we are going to incur to stem that rising sea level.
And just, I wanted to address it, sort of also the push and pull, the tension within public nuisance, because my understanding is that when your case was dismissed, and we should clarify, right, that though the San Francisco, Oakland, and New York suits have been dismissed in federal court, again, San Mateo County, Imperial Beach, Marin County, those states continue to move through the California state courts. But in your case, the judge dismissed your case in part arguing that the benefits of fossil fuels in part sort of offset the nuisance, right? Saying, well, it's hard to adjudicate this because also society gets a lot of good things. And so I'm wondering if you could just talk about that a little bit, about how the challenge of making the case that the harm outweighs the benefit, or do you not even have to go there?
Well, so it's true that in public nuisance you balance the social utility of the conduct. We were dismissed very early before we got to the merits. That was one concern of Judge Alsup. In his order, he was concerned that society has embraced fossil fuels. And so how can we hold these companies responsible for something that has been a collective decision? And why these individual companies. The other thing that Judge Alsup indicated was that perhaps this problem is too large for the courts. Perhaps it would be better to have these problems legislated by Congress rather than having a court in a particular district decide it. It's hard for lawyers to...
That's the Berkeley chuckle.
Yeah.
The Berkeley sardonic chuckle.
We have a San Francisco version ourselves. But it's hard for lawyers to accept that, right? When you embark upon something where you think that there is real change through litigation, and not only litigation, right? We work alongside all of these other strategies. There's not one strategy that's going to solve the climate change issue. We collectively have to work together looking at the problem through the lenses that we have as an expertise, whether it's a scientist or an organizer or lawyers. But it's hard for me as a lawyer to accept that a problem is too large for the courts. Because if I believed that, then I wouldn't take on half of the battles that we end up taking on, right? So again, this is the production of fossil fuels. Emissions is a different thing, but production is not something that Congress has weighed in extremely heavily on, right? And so it seems weird to defer to a regulatory structure that doesn't exist.
So speaking about sort of the larger context that the judge was talking about, Stephen, I'm wondering if you could put these cases in the context of also what's happening internationally, right? Because yes, there's these now cases moving through various state courts from jurisdictions across the country, and including some. We should point out you had the earlier map here, Christina, but they're not all coastal areas. We've got areas in Colorado soon over wildfires and bark beetles and stuff. But what's happening in other places and also overseas?
Sure. So when we started looking at this at the Center for International Environmental Law, we didn't want to focus in on one kind of climate impact or on one kind of cause of action. We really were looking for the cross-cutting legal principles that would apply in basically any circumstance. And what we found in the US and common law of torts, in the civil law jurisdiction law of non-contractual obligations, and in international human rights law, is that the question of when is someone responsible for a harm typically boils down to about 3 questions. First, is there a causal relationship between the actor and a harm? Did the actor know, or should the actor have known, that their behavior would cause the harm? And did that actor have the opportunity and the capacity to avoid or mitigate that harm? And so that framing of those questions, and this has been, I mean, we didn't invent this. This has been reiterated by the International Commission of Jurists and Oliver Wendell Holmes. But this basic frame of responsibility is where we're seeing a lot of activities that separately might not look like what we think of traditional climate litigation. And so I want to talk about 3 that I think make this point in themselves. First, there's a case of a Peruvian farmer named Saul Liuya. I don't know if you're familiar with this case. He lives in a valley beneath a glacial lake, and the glacier that dams the lake is melting due to global warming. And so he is suing RWE, the German utility, for only 0.5% of the cost, 1% of the cost of what it would take to shore up the glacier and install a warning system and basically ensure that his community had the ability to live. But again, premised on this idea of the attribution and the relative percentage of atmospheric carbon that RWE is responsible for. And this is really exciting because the German courts, again, this is suing a German company in a German court, they decided to hear evidence in the case. So this case is moving forward. And I think it's really important because it demonstrates both that, you know, this is not just a global north thing, not just a US litigious kind of activity, but really that the global scope of the operations of these companies and the global impacts that their operations are causing will lead to liability globally, from Germany to Peru and everywhere else. Another, it's not actually a case, but an investigation that's going forward is at the Philippines Commission of Human Rights. After the devastating Typhoon Haiyan, they accepted a petition to investigate the investor-owned carbon majors to determine whether or not their behavior constitutes a violation of human rights. And this is really important. Again, this is a different kind of tribunal, but they're asking a lot of the same questions and bringing this question of climate liability out of just, again, the US tort context or the German civil non-contractual obligations context, and really into the realm of human rights, where it appropriately belongs, not instead of, but in addition to. And then finally, there are a pair of cases brought by the Conservation Law Foundation in Massachusetts that I think are really instructive, because they're climate cases, but they're not, I think it's up to 14 now of the sort of traditional damages cases include theories of nuisance and negligence and products liability. But these cases, one against Exxon, one against Shell, are premised on facilities that these companies own and operate that are adjacent to bodies of water, and were required to apply for Clean Water Act permits. And as we know, these companies knew that sea levels and storm surges would become a more significant threat to their facilities and would lead to releases of effluent and toxins greater than what is in their Clean Water Act permit. So we're seeing Clean Water Act litigation, which is fundamentally what these cases are, but premised on this issue of climate impacts and a changing climate. And so when we look at these three, the Liuya v. RWE, the Philippines investigation, and these Conservation Law Foundation cases, in addition to the, I think it's 14, but I could have that number wrong, number of cases of...
It's 12?
It's 12?
12, 13? I think Rhode Island was 13.
13. Okay, yeah, then 13 cases of what I think are more traditional, but still critical, sort of basic tort damage cases. We can see that climate litigation is going to take a whole bunch of forms that we can't predict and shouldn't try to steer, and that it's not limited to this legal system, it's not limited to the few precedents that we have, and that it's growing.
So, Stephen, you said something really interesting. You said, you know, especially in the Philippines case, it puts this conversation in like a rights-based, a human rights context. And man, I wonder if you could talk about that. Again, you were talking about how important it is to have a villain when you're doing social change work and culture change work and trying to shift the political system, but also how important it is to make sure that these suits, and if there ever are the creation of abatement funds, are assisting those and are geared to assisting those who are harmed first and worst, and how that kind of fits in with the larger climate justice narrative and larger climate justice message.
Yeah, absolutely. And another way of thinking about it is this connects to the long-term environmental justice framework of polluter pays, the idea that if you cause the problem, you have to be part of paying for the solution. So I think that's an important framework to bring in. Yeah, building a little bit on what you were saying about human rights, there's another dimension as well that we haven't talked about as much, which is the human rights abuses on the extraction end. And if you look at some of the reporting done by groups like Civicus and Global Witness, some of the most dangerous places to be an activist are places where there is a heavy amount of fossil fuel extraction. And a lot of people are familiar with Cancerowiwa and Shell, and there are a lot of examples like that in the present day. I just heard about one on Saturday. So there's lots and lots of examples where these companies are targeting activists. So we can't leave that out of this discussion as well. And I think in terms of the impacts on communities, qualifying a little bit what I said about the villain, it's not as much that we needed to create a villain. They were already there. and if you live, particularly if you live in a community next to a coal plant, if you can't get water because it's been so damaged in your community, if you have asthma, you're already living through this. And so, while we're here today, there's a Solidarity to Solutions Day of community-led solutions ideas happening in San Francisco as part of the Global Climate Action Summit. So there's a lot that's being discovered and discussed while we're here at this summit on this exact theme about what communities are experiencing, what they're doing about it, how to show solidarity and support. So I think this conversation is very tied to that conversation. And if you don't live near an extraction site, and if you're not being immediately impacted by climate change, there is a lot you can do to show solidarity. And one of those things is you can organize in your community to help figure out how you can get involved in one of these cases. Because there are things that you can do as an organizer to participate. And there's people in this room who know more about that than me who could sign you up to get involved. And that's a lot of what we try to think about at 350 and in a lot of our sister and brother organizations is what are the avenues for activists to participate? And this is one very good way. I think the other thing I want to point out about the link with community organizing and what we're talking about here is the point you were making, Yvonne, about deferring to a regulatory structure that doesn't exist. I love that. I love that line. And there's an interesting component of this as well, where we've been experiencing inaction from Congress for quite a long time, predating the present administration. And so there have been lots of attempts to find other venues for action, whether it's the courts or investors, on and on and on. But while we're doing that, we're building power that could help us change Congress. So it does actually become part of a mutually beneficial cycle. So hopefully that can be part of our tool set later on because of all the work we're doing in all of these other venues. But I think that's often misunderstood, that we're doing this outside of Congress because we don't think it's good to have some kind of national policy on climate change. Quite the opposite. We're trying to build power and get that too. So wanted to make sure that that was in the conversation.
Like, if Shell and Exxon were genuinely serious about dealing with this in Congress, I'm sure the climate movement would take them up on the offer.
Absolutely.
So one thing I'd love to hear from any of you or all of you, if you want to address this, is how, if at all, it changes the conversation or changes your work and your advocacy, whether legal advocacy or grassroots or scientific advocacy, the fact that because of these lawsuits and because of a very interesting, in some ways unprecedented climate change tutorial that federal judge Alsup held earlier this spring, in which all of the major carbon polluters, the defendants, acknowledged that humans are driving climate change. Does that public acknowledgement in a court of law, does that change things now? Does it change the ability to perhaps crack through, the science deniers, or is it kind of moot?
Yeah. I would just say the thing that the oil industry is really, really good at is constantly resetting the clock and moving the goalposts, and they go from denying that it's possible to saying that, oh, it's uncertain or it's not going to be a big deal, to and this is just another stage in that shift. I think the fact that they were basically forced to admit that climate change is happening and that it's real, finally, is evidence of the tremendous work of activists, and that they were able to push the envelope far enough where it became completely unreasonable and untenable to deny. In terms of what it means for our work, I think it means we keep doing what we're doing.